hasn't alleged that Bryan Kohbergers' DNA was on the knife sheath.
No, I'm not talking about the knife sheath DNA. I'm talking about what they tried to match it to.
Your Honor, I would answer it this way. The way that those databases work is looking for shared DNA. Those databases don't turn out a name and say this is
I have a
suspect.
privacy interest against any of my relatives that might want to upload their DNA to one of those systems. I should be able to stop them from doing that because I share some DNA with them.
That is certainly not what I'm saying. What I am saying, Your Honor, is if somebody takes your DNA and uploads it, I think you have a privacy interest in your own DNA.
Not necessarily in, let's say my DNA is taken lawfully. What privacy interest do I have in the search of the DNA of others?
That's a loaded question.
Why is it a loaded question? Isn't it a factual question?
Well, it is, Judge, but you're assuming that the DNA was taken lawfully, and our position...
I agree. That part is an assumption. In my hypothetical, I said my DNA was taken lawfully. Why would I have standing to object to the search of other people's DNA simply because I might share some genetic information with them because they are distantly related to me?
Well, Your Honor, our position is that this work was not done lawfully, that it was unlawful, that there needed to be a warrant, that this was done outside of a warrant.
Okay, for starters, right, with what Ann Taylor's saying, it's been known for a long time and publicly stated, and I mean, if I know it, then Ann Taylor definitely knows it. When they got a match through the IGG, they never used that match to obtain any search warrants against Bryan Kohberger. So although they had the match, they never used that to obtain any search warrants against him or used that against him. They just had that to their best knowledge. DNA that's in question, and it's weird that Ann's fighting, is the one that's actually obtained after Bryan Kohberger's arrest. That's what's really difficult here, is that it's almost like Ann saying that the DNA that's obtained was unlawful when it wasn't, because it was used after he was apprehended.
And I'm not asserting on behalf of anybody else in this, any relative, anybody who might have been named or not named. This is about an identification process. It needed to be a lawful process. It wasn't a lawful process. It was in violation of Mr. Kohberger's rights.
How on earth was this in violation of his rights? Again, if they obtained the sample after they arrested him from a cheek swab, like we know they did, then that is not in violation of the individual's rights. It's almost as if Ann is stating to some degree here that because they found DNA on a knife sheath at the scene of the crime and were able to later on match that against her client, he somehow has a privacy or violation issue where that should trump the DNA that's found at the scene of the crime.
I don't know how he cannot.
How is it in violation of his rights?
Excuse me?
How is it in violation of his rights?
Well, Your Honor, he's been in custody
You're
for
saying
2
that
years.
I understand your position, which frankly is not well supported in the law, that if hypothetically here he went to this crime scene, committed these murders, and left DNA on a piece of evidence, that he now has the ability to object to that evidence being searched for identification purposes.
Pretty much like what I just said there, except obviously worded a lot better from Hitler. But what he's stating there is right, and that has never happened. It's like saying you can't use the DNA at the scene of the crime against me because it's my DNA. It just, like, what the hell? I'm a bit clueless as to the play that she's even going for here to bring this to the attention to the court to this degree. I understand that pretty much Ann's best avenue here is to exhaust all avenues, but this is wild.
There's no case that suggests that concludes that. And it seems to me to be an extreme position to take in light of the case law, and I'm trying to understand how you get there.
When it came down to what Ann Taylor was doing here with the IGG, I actually thought she was going to have a lot better play. So I thought that this would be that she was using some kind of almost loophole that she didn't have all the information from the FBI as to how specifically they obtained that IgG. And what I mean by that is, did the relative of Bryan Kohberger use the opt-in service for that individual's DNA to be used by law enforcement? And I was unsure if they were aware if the individual or the relative of Bryan Kohberger had opted into said service. Because if they hadn't opted into the service and then they used the DNA, then there would be a massive problem. Because that individual hasn't opted in for any law enforcement to be able to compare their DNA to. That then would be a privacy issue. You instead state that because the DNA found at the scene of the crime that was later compared to him after he was arrested matches him, means that it's a privacy issue, is one of the wildest things to try in a courtroom. And it may sound like a really odd thing to say, but I thought that Anne was going to come a lot better prepared than this.